It provides us with the ability to get the UN Committee's view on whether or not Canada is complying with its international obligations.
At a public forum on the Canadian Constitution's Notwithstanding Clause in June, the message from Pearl Eliadis, a Montreal human rights lawyer and McGill University professor, is that the use of the Notwithstanding Clause, most recently used by Quebec's CAQ government for Bills 96 and 21, could be challenged beyond the Supreme Court of Canada by filing a complaint with the United Nations Human Rights Committee.
That is only available when the court of last resort, which is the Supreme Court, has turned it down. What would happen if it went up was that there would be a review of the materials by the Human Rights Committee, and the committee would issue what's called a view. It's not a binding decision, it's a view, but Canadian governments in the past have taken these views seriously.
Going to the United Nations would be a public embarrassment for Canada. I don't think the United Nations can actually sanction Canada. They might be able to pass resolutions that would be unpleasant and have unpleasant political consequences for Canada. It certainly would hold Canada up as not being a model of democratic fundamental rights and freedoms.
Eliadis adds that the United Nations Human Rights Committee has been set up to review complaints to determine if nations such as Canada are compliant with their international obligations. The Notwithstanding Clause can be invoked by Canada's Parliament as well as provincial and territorial legislatures to pass laws that may violate certain charter rights.
So the Notwithstanding Clause, in general, leaving aside the specifics of Bills 21 and 96, the Notwithstanding Clause in general does not, in my view, comply with our international obligations and the way in which the treaty body is prepared and drafted.
In a statement to City News, the Quebec government said they would not say why they are using the Notwithstanding Clause for Bills 21 and 96 because they are before the courts, but explained that the Notwithstanding Clause is a way to defend the prerogatives or rights of the National Assembly of Quebec within Canada.
Both Bills 96 and 21 violate the right to equality for religious women, for people of faith who wear visible signs, religious signs. They violate the rights of the minority, the linguistic minority in Quebec, of course, which is the Anglophone minority.
In Montreal, Gareth Madoc-Jones, City News.